Welcome to today's luncheon discussion, Creatures of Statute 3, Congress's responsibility to answer the major questions. My name is Stephen Schaefer, and I'm the director of the Federal Society's Regulatory Transparency Project. The Regulatory Transparency Project, also known as RTP, is dedicated to examining how the administrative state works in modern American government and how regulations either succeed or fail Americans, and think about how we might improve them. Please join us this Wednesday, October 19th, for a luncheon on a global energy crisis and the Federal Regulatory Commission. It's at the Mayflower Hotel this Wednesday from noon to 1:30. And if you're interested, as you leave here, you can stop at the table and we'll get you registered. Today's event is brought to you by the Regulatory Transparency Project and the Capitol Hill chapter for the third in a lecture series on the administrative state. Thank you to my team and Savannah Griesinger's team who helped to co-plan this event. The subject of the discussion will be the major questions doctrine and how Congress may respond to the Supreme Court's decision in West Virginia versus EPA. Now for brief introductions to our stellar panel of experts. First, we are honored to have with us the Honorable Trevor N. McFadden. Judge Trevor McFadden was appointed to the United States District Court for the District of Columbia in 2017. He has experience in both public service and in private practice. He served in the Department of Justice as counsel to the Deputy Attorney General and as Assistant U.S. Attorney in the District of Columbia. Then he became a partner at Baker & McKenzie LLP, where he focused on white-collar investigations for 4 years, and then served again in the Department of Justice as Deputy Assistant Attorney General and acted as the second in command of the department's criminal division. As Deputy Assistant Attorney General, he managed the division's fraud and appellate sections. We're also really happy to have with us today Professor Sarah Binder. She is a senior fellow in governance studies at the Brookings Institution and professor of political science at George Washington University, where she specializes in Congress and legislative politics. Professor Binder's current research explores the historical and contemporary relationship between Congress and the Federal Reserve, and she is the co-author with Mark Spindle of The Myth of Independence, How Congress Governs the Federal Reserve, from Princeton University Press in 2017. She's also an associate editor of the Washington Post Monkey Cage blog. She earned her PhD in political science from the University of Minnesota in 1995 and a BA from Yale University in 1986. We are also thrilled to have with us Daniel Flores, who is the senior counsel on the Committee on Oversight and Reform at the U.S. House of Representatives. Prior to his current position, he served in the U.S. House of Representatives as chief counsel for the Subcommittee on Regulatory Reform, Commercial and Antitrust Law for the Committee on the Judiciary, the chief counsel to the Subcommittee on Courts, Commercial and Administrative Law, and the chief minority counsel for the Subcommittee on Commercial and Administrative Law in the Judiciary Committee. Previously, he also served as acting associate deputy general counsel for the U.S. Environmental Protection Agency and senior trial attorney for the U.S. Department of Justice, Environment and Natural Resources Division. Note, as always, the Federal Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. Judge McFadden, over to you.
Thanks, Steve. It's a pleasure to be with you all today. Really an honor for a judge to come up to the Capitol Hill and feels very appropriate for us to be with you all in this place to discuss the major questions doctrine. This series is entitled Creatures of Statute, and I, as a federal judge, this strikes home for me because as much as we like to say that Article 3, we're in the Constitution, all of that, actually my position as a U.S. District Judge, my court, are creatures of statute, and so it's appropriate for me to come here and be with all of you, many of you who I know are involved in the first branch, Congress. So as Steve said, we'll be discussing the major questions doctrine today. That is the idea that Congress, not agencies, must answer significant questions about agency authority. I have the sense that it reflects a judicial intuition often that an agency in a particular case is making a power grab. That is, that it's acting without congressional authorization to take power to itself that Congress never intended. It reminds me of Justice Scalia's famous claim that Congress doesn't hide elephants in mouse holes. More practically, if less memorably, the court has described this doctrine as a clear statement principle. And it is therefore similar or comparable to other clear statement principles, such as the judicial presumption against legislation with retroactive effect, and against legislation that abrogates state sovereign immunity. Each of these doctrines serves as a type of constitutional avoidance function, and that is that courts are reluctant to recognize a statutory construction that raises questions about the constitutionality of the statute as written. These clear statement principles are canons that can be contrasted with the major question doctrine's big brother, the non-delegation doctrine. That doctrine holds that there are some legislative functions that Congress can't entrust to an agency, no matter how explicit Congress makes the legislation. The major questions doctrine, which can arguably be traced back to the late 1800s, has been enjoying something of a heyday, I think it's fair to say. Before this year, I'd say one of, if not the leading major questions doctrine case was FDA versus Brown and Williamson, a 2000 Supreme Court case that rejected the FDA's attempt to suddenly regulate tobacco, the cigarette industry, after the agency had long acknowledged it had no such power under existing laws. But Brown and Williamson also invoked Chevron, the famous and now somewhat controversial doctrine that requires judicial deference to reasonable agency constructions of their relevant statutes. This has arguably muted the power of the major questions doctrine in the past, as unreasonable agency statutory power grabs would fail under Chevron in any event, regardless of the major questions doctrine. And so perhaps for that reason, we have not seen a whole lot of major questions cases in the past, at least cases where the Supreme Court has struck down agency action under the major questions doctrine. But during the pandemic, the Supreme Court either implicitly or explicitly repeatedly used the major questions doctrine. First, to strike down Health and Human Services' attempt to unilaterally extend the eviction moratorium. And then just earlier this year, I believe, OSHA's imposition of a vaccine mandate for all companies with more than 100 employees. The Supreme Court also struck that emergency regulation down. Both of these decisions, however, were on the court's emergency docket with terse opinions, and at least some people question the precedential effect of these emergency docket opinions. So while I think it's fair to say that those pair of cases raised the profile of the major questions doctrine, they themselves also, frankly, raised as many questions as they answered, which leads us all to this last term's blockbuster case, West Virginia versus EPA. And it's to that case we will now turn. Mr. Flores.
Thank you, Judge. West Virginia v. EPA was a very eagerly anticipated decision, certainly in the ad law community, I think also in the broader community interested in all things separation of powers and constitutional law. Let me try and sort of set the table for a lot of our discussion of what the case may mean by walking through the facts and some of the different opinions that were issued. The case arose out of our national debate about climate change, as most of you probably know, on the question of whether and how to respond regulatorily to that issue. Vis-a-vis carbon emissions, Congress has yet to come to a consensus on whether and how to grant any agency some new overarching authority to tackle the problem. The Obama administration and the Trump and the Biden administration, they have all examined, whether and how to use existing Clean Air Act authority as a result to deal with the problem, beginning with the Obama administration's Clean Power Plan, which was the origin of this case. In the case, the Supreme Court answered whether an old and relatively obscure provision of the Clean Air Act enacted in 1970, subsection 111D, on existing sources, could be interpreted to support broad regulation now of carbon emissions from power plants. As I said, the provision was enacted in 1970, had rarely been used in all that time by EPA. It was a small part of a broader provision about new sources. Perhaps that's why it hadn't been used much. But the Obama administration's use of it to address climate change, it was a classic case, at least in my view. And I should say, too, by the way, my remarks, they're just my own personal views, not the views of Ranking Member Comer or anyone else. But the Obama administration, in my view, it was a classic case of an agency, of an administration wanting to tackle a major new question, finding itself frustrated by Congress not yet having acted, and casting about in existing portions of the U.S. Code, far and large, to find what statutory authority that existed that might support the effort it wanted to undertake, and tease out authority to address a major new question from old statutes originally designed to address other matters. The holding in the case, as Judge McFadden suggested, was essentially to articulate a new canon of avoidance among clear statement canons. Based on the court's oral argument, one I think would have reasonably expected the court might well have not gone that route. Instead, simply resolved the question as what we lawyers call a Chevron Step 1 matter, applying traditional canons of construction long before articulated to Section 111 and finding, no, this authority just wasn't there. So case closed, that's it. No new doctrinal ground broken. Some others were hoping that the case might actually be a vehicle for breaking new ground on non-delegation. The excitement was probably stoked for that by Justice Gorsuch's dissent in 2019 in the case of Gundy v. U.S., in which he signaled it was a dissent, right? A dissent that was joined by Chief Justice Roberts and Chief Justice Thomas, and certainly sympathized with by Justice Alito, to take another look at the existing non-delegation standard and perhaps recalibrate it or more. Justice Kavanaugh did not participate in that case because he had not participated in the oral argument. It was an 8-vote court, divided 4-4, so that doctrinal ground couldn't effectively be broken there. But people had been waiting for it ever since, and this was the first big case that presented perhaps a window. But again, as the judge said, essentially what the court did in Chief Justice Roberts' opinion for the majority was to evolve the pre-existing concept of major questions, which had sort of inhabited traditional construction land, Chevron deference land prior to that, and essentially declared a full-blown canon of its own, now a clear statement rule, that before the court would find that a statute conferred upon an agency authority to address a major question, there had to be a clear statement of that in the statute. Unfortunately, at least by my lights, the Chief Justice's majority opinion, while it has a lot of detail in it, it didn't really sort of cleanly structure what the doctrine contained, what it might mean, how it might be implemented by the lower courts. Justice Gorsuch, perhaps for that reason, he wrote a concurrence that was joined by Justice Alito that helped to provide some more structure for the kinds of factors the courts might look at in trying to implement this case. I'll walk you through them. It takes a little bit, but they're illuminating. He acknowledged at the outset that, as the majority opinion had stated, when agencies claim the power to make decisions of vast economic and political significance, they must do so pursuant to a clear statement from Congress. Justice Gorsuch articulated several factors that could help guide the lower courts in identifying whether an agency was attempting to address such a major question. There were three. that he pointed out. First, whether the agency is seeking to assert authority to address a question of great political significance or end an earnest or profound debate across the country. Obviously, those issues apply to climate change. Second, is the agency seeking to regulate a significant portion of the American economy or require billions of dollars in spending by private persons or entities? Again, something that applies to climate change. Third, is the agency seeking to intrude into an area that is particularly the domain of state law? That one would be a little trickier, but it's very helpful to have the articulation of that as a potential factor. And then Justice Gorsuch articulated a set of factors to help identify when, in a case involving an identified major question, the statute at issue contained a clear enough statement from Congress to authorize the challenged agency action. First, he said the court should look to the place of the relevant legislative provisions in the overall statutory scheme in question. Those of you who are lawyers will recognize that as something that's pretty familiar from lots of prior decisions. A few things were identified as things that would not do. Oblique or elliptical language, he said, will not provide a clear statement. Nor may agencies succeed when they try to find elephants in mouse holes, as the judge mentioned earlier, and neither may agencies rely on so-called gap filler provisions. Second, the court should look to the age and focus of the statute in question. Third, the court should look to the agency's past interpretations of the statute, especially the agency's contemporaneous reading of the statute at the time of its enactment, and any long-held agency interpretations. Fourth, the court should examine whether there is a mismatch between the agency's expertise and its claimed authority. So 7 factors there in 2 different bins of factors, many of which, again, those of us who are lawyers, we recognize as things that echo things to consider in cases under other doctrines and other analytical frameworks that courts apply. So query where how much of this is really new, other than it's sort of refounding as a clear statement canon, and also query how easy is it going to be for the courts to sort of consistently implement this new standard. If these are the factors and they're open to ambiguity, to say the least, in a number of ways. One other thing I'll note is, Justice Gorsuch's concurrence is very intriguing because it's largely silent to the dissent in Gundy that I mentioned earlier that had been the basis for a lot of people to hope this would be a big non-delegation case. He did note that, citing that dissent, that the major questions doctrine articulated by the court constituted a clear statement counterpart to the Constitution's vesting clause in Article 1. That's the first clause of Article 1, which says all legislative power shall be vested in Congress of the United States. But he left unaddressed completely whether there is additional work to be done via the court's non-delegation jurisprudence regarding what Congress can and cannot delegate to the legislative branch. One day, perhaps soon, the court may have to confront the question whether in a statute in which Congress delegated by a clear statement authority to answer a major question by rulemaking, that delegation violated Article 1's vesting clause by delegating non-delegable power. So let me offer you quickly, and then turn it over to Sarah, a few observations on just what is delegation and a few related topics. Roughly speaking, it's simply a permission given by Congress, explicitly or implicitly, for an agency to fill up the details left unaddressed by Congress in the statute Congress wrote. Over time, those delegations have grown quite broad and quite significant compared to the early days of the Republic. There could be a lot of reasons why. But broad delegations are made possible especially by the Supreme Court's current and longstanding principle for determining what's a permissible delegation of authority by Congress. Essentially, all that is needed is that in the statute, Congress lay down a quote-unquote intelligible principle by which the agency is guided in its framing of its own action to implement the statute by legislative rule. The question arises, why does Congress delegate broadly? There are a myriad of factors for that. One is to afford agencies flexibility in adapting their regulations to changing circumstances. Another is that the ultimate solutions to line drawing exercises can benefit often from the application of specialized agency expertise. Sometimes that's brought into the legislative process, in the hearing process and elsewise. Sometimes it doesn't get all the way there, and Congress may consider it enough to draw a rough line and leave it to the agency to clarify matters further. Another reason is that every word in a congressional enactment is subject to compromise during the legislative process, and sometimes compromise down to the final detail just can't be reached within the time a given Congress has to act. And another is that Congress over time has increasingly taken on bigger and broader problems. And again, the time it determines to allot to a solution in a given term of Congress, or a few, may just not be enough to get to the resolution of every detail. And the list goes on and on. We're all aware of major recent examples. Dodd-Frank comes to mind to me. Obamacare comes to mind to me. There are a lot of incentives for members to pass broad delegations. Many have observed over the years that when Congress delegates, it's able to pass over to the executive branch some of the accountability for the decisions at issue. In each term of Congress, as I mentioned before, the press of competing business might not allow Congress to wrap up a question. But in my own view, ultimately, perhaps it's the Supreme Court's own jurisprudence that provides the greatest incentive, and that is that the intelligible principle standard is so minimal, so broad, that it allows Congress to delegate broadly. And since Congress can, Congress does. It's a feature of human nature. That kind of thing happens in circumstances. And that's actually part and parcel of the court's jurisprudence, because the court itself has recognized that. If Congress were not permitted to delegate so much, in the view of many, it would be hard for government to function efficiently in the way that we know. I'll leave it at that. I've gone on for a while. I'll turn it over to Sarah.
Great. Excellent. Well, thank you very much. I trust you can hear me in the... Okay, excellent. Well, thanks very much for including me. I thought I would offer some observations about the major questions doctrine from my perspective as a student of Congress and not as a lawyer. So my argument boils down to this. If a central goal of the major question doctrine is to pare back in some way the administrative state by creating incentives for Congress to delegate with greater specificity, I'm not yet convinced that the major question doctrine will get us there. It may over time, but currently I don't really see it, in part because I think there's some complications here, most of which Daniel has touched on. So let me offer 4 complications to the effectiveness of a major question doctrine. So first, the doctrine is a bit ambiguous, as the judge and Daniel have suggested. Like, what is a major question? What makes a provision economically or politically significant? Relatively easy to set a dollar amount, as Congress did in the Congressional Review Act for taking the capacity to review major rules. But what about political significance? How would the court know that? How would lower courts know that? And why should that determination be made by the courts, and why only on major questions? And then from Congress's perspective, how would it know what a court majority would count as a quote-unquote clear statement of intent to delegate such authority to an agency? I think the danger here is that the major question doctrine risks enlarging the power of the courts rather than the power of Congress, which then diminishes the opportunity for Congress to try to exercise greater control over an unelected bureaucracy. Second complication, and Daniel sort of touched on this already, the court majority is not advancing major question doctrine in just a judicial vacuum. Certainly Chevron is prevailing precedent, and so is, and I think as important, the century-old intelligible principle standard. And Congress really always has some sort of policy principle in its legislation. So I'm not sure that the major question doctrine right now can provide sufficient incentive for Congress to change how, in what form, it delegates. Third complication, ambiguity in statute is often the price of enactment, right? Especially in a polarized environment where the parties often disagree about whether an issue is a problem, let alone how to address it. And ambiguity then is often the legislative solution. Bridging differences between the parties, between the chambers, or within the parties, those sorts of compromises often take the form of delegating discretion to the experts in bureaucracy. And so not spelling out the precise definitions in statute, what is a sound banking system? What is fair and equitable access? What is, from the EPA case, what is the best systems? And so forth. That is often the price or the path to enactment. So sending ambiguous statutes back to the institution that failed to be explicit in the first place probably leads to inaction on Congress's part, sometimes for better and sometimes for worse. Fourth complication is that the agencies come out stronger, potentially come out stronger, not weaker, under the major question doctrine. Because keep in mind, agencies are also watching what the courts are doing, and so they can, if you will, sort of price in these new precedents, or this new precedent, to try to avoid judicial review, right? They want to kind of court-proof their own agency decisions. One new political science study shows that the likelihood of judicial review leads agencies to invest in more personnel and processes that emphasize due process, right? So the more cases your agency has before the courts, the more those agencies hire administrative law judges and sort of judicial-ish personnel to make sure, or to try to reduce the chances that the courts, that they'll end up in court, or that they'll be overturned by the court. Relatedly, if the court wants Congress to provide clear congressional authorization, as Daniel just suggested, agencies can and will continue to provide that expertise to the Congress. And that all leaves power in the hands of bureaucracy to keep interpreting the statutes through these somewhat ambiguous, often very ambiguous delegations. So I will stop right there and give you back the floor.
Thanks so much, Dr. Bender. Why don't we start out our conversation? Let me say, I think the three of us are going to spend probably about 15 minutes or so chatting, but we're saving the best for last, and that is getting to hear from you all. So if you do have questions, either from the remarks you've heard thus far or later on, please keep them in mind. We do want to get to hear from you all. But first, Daniel, maybe you could respond to Sarah's comments.
Sure, happy to. You know, I found it very intriguing, the suggestion that it's not quite clear exactly who's more powerful in the end, or quite why the court was doing what it was doing with this decision. My own hunch, because I had the same kind of reaction when I read the decision, was this actually may be just the first step in a two-step process in which the court is engaged. As I mentioned in my comments, in the Gundy case, there were 4 justices who, by their writing, were pretty clearly in the corner of doing something new with regard to the equilibrium on what's delegable and what's not. And not long after that case, or in that same term, there was a I think it was a shadow docket statement by Justice Kavanaugh to the same effect. Remember, he had not participated in Gundy, but he issued a simpatico statement, let's put it that way. So there you have 5 votes for taking on anew the non-delegation principle. But that principle, that's the standard for delineating what's legislative and therefore non-delegable and what is not legislative and therefore delegable, is notoriously thorny, tricky, difficult to identify and work with. And I suspect what's happening is that in the interim, while a majority of the court is working on a new standard, ultimately on non-delegation, it prudentially adopted this new canon of a clear statement rule to help them avoid cases in which they might have to declare what's non-delegable. You know, one, because that's a very big statement. I mean, anytime that they do that, they're going to be overturning a federal statute. That's a momentous thing. And also, they may need more time, really, to sort out ultimately what a majority can agree on to do with that development in the doctrine. So I'd say, you know, keep your eyes out maybe for something new on that, in which this could go sort of hand in glove. The one standard from West Virginia EPA to help narrow the cases that are the toughest for the court, and finally a new standard on non-delegation to deal with the smaller remainder.
Sarah, let me ask you, in the lead dissent, which we haven't discussed much, but Justice Kagan notably accused the West Virginia versus EPA majority of turning the major questions doctrine into a get-out-of-the-text-free card, which I'm sure kind of stung some on the majority. Do you agree with this critique, and is this an example, to your mind, of a conservative majority rejecting textualism when it suits their policy preference?
So I think I come down to the yes and no, right? In this narrow case, it's hard to sort of see sort of public meaning textualism, right? I don't quite see that as what was going on. It's hard to square that with the looking for evidence of, well, first of all, trying to decide whether this was an unusual or exercise of or interpretation of congressional power. So in this narrow case, I could see where that criticism has some bite. But on the no side, right, this isn't the only case where the court has either explicitly or implicitly invoked major questions or tried to develop major questions doctrine. And the use of the doctrine in those cases, it's not strictly conservatives striking down Democratic administration rules, right? There's some vice versas, right? There's a whole mix, and there were some larger majorities as well. So I think the broader sort of cohort of cases where the doctrine has been applied or sort of developed, I don't know that get out of text-free card criticism exactly, explains what's going on.
Daniel, you discussed the non-delegation doctrine earlier, and I mentioned it as well, this idea that there are some delegations of power that are impermissible, no matter how clearly Congress tries to grant them to an agency. And to my mind, this major questions doctrine is almost kind of a junior varsity version of the non-delegation doctrine. Some people have suggested that courts should really be focusing on that doctrine, and that the major questions doctrine is something of a fudge to avoid having to declare a statute unconstitutional altogether. What's your reaction to that? And are both doctrines workable and independently justifiable?
Yeah, I think they're both workable and independently justifiable. I understand the impulse. I wouldn't myself call it a fudge. I'd call it more the court sort of identifying a prudential intermediate step to take in addressing this whole body of cases in which there may be very questionable delegations. And of course, keep in mind, anytime that something may come close to the line of being non-delegable, it's pretty likely that's going to be a major question. So they kind of go hand in glove together. I think that the chief writing the decision that articulated the candidate is something that can be understood by those who have followed the chief for many years. He tends to be an incrementalist in measures while having bold goals in the end quite often. And I think they're inching their way towards that. Whether they ultimately get there, I don't know. And again, I mentioned earlier, it's a momentous thing whenever the court sets aside something as violating the non-delegation doctrine. It's only happened, I think, twice. But it's not just momentous for that statute. A recalibration of the non-delegation doctrine is something that could affect hordes of statutes currently in the U.S. Code. I mean, it doesn't, to me anyway, seem to be something that's susceptible to only prospective application. And, what Congress would be able to do with the morass of existing statutes instantly on the wrong side of constitutionality because of a new standard being articulated is probably one of the biggest issues Congress would have had to confront in its history. So I think it's very, very prudent for the court to take the kind of measured approach it seems to be taking.
I would just say as a political scientist that this seems to be the sort of the half step or the quarter step that can get 5 or more votes. And perhaps the strategy of separating sort of unintentional delegations from intentional delegations, maybe that's like the route for which there is 6 votes or are 6 votes for now. Yeah.
as Daniel said, the non-delegation doctrine has only actually been invoked to strike down statute twice by the Supreme Court anyway, and both of those were almost a century ago. So this is something of a dormant doctrine, at least at the Supreme Court, despite Justice Gorsuch's best efforts. Although just was it earlier this year, I think the Fifth Circuit, many of you may have seen, declared that the SEC's ability to bring fraud suits in either federal court or in front of its own ALJs, that was a violation of the non-delegation doctrine. So I think, and there are also, I think, some of the same criticisms that people levy against the major questions doctrine, including how does Congress know if a question is major, pertain to the non-delegation doctrine and this intelligible principle idea. Right. Justice Scalia famously kind of questioned whether isn't this intelligible principle basically a policy choice, and really is that something that courts should be doing? So in some ways, the difficulties on one side or the other.
Yeah, I hear you. I'm also intrigued by Sarah's reference to the intelligible principle doctrine. I think Chevron as well you mentioned, and as I was thinking about how the case might affect how Congress goes about its business in the near term anyway. I think one has to keep in mind that Congress is still going to be legislating against the backdrop largely formed by the existing intelligible principle canon or standard, and by the Chevron doctrine, which is all about deference to administrative agencies when they interpret these statutes. And so whether the overlay now of the major question doctrine into that rubric is going to markedly change how Congress writes statutes, I'm not sure. It's very hard to say. I think it's also worth noting too that because of the ambiguity in the West Virginia case, how it laid out this new canon, it's likely to take the lower courts a while to really fully flesh out the contours of the doctrine. And while that's happening, Congress won't quite know yet, okay, what's the ultimate standard? So it may not yet have quite the impact on Congress's behavior that people think. And of course, the legislative process is always one that has a myriad of issues that affect how a compromise is reached, only one of which is what may happen to the ultimate product in court. So it's very hard to speculate how this decision may change Congress's behavior. I think it's most likely in the near term to affect agency behavior with regard to just with how much alacrity our agency is going to really try and push the envelope when they're dealing with a new question using the old statute.
One thing I noted, your initial remarks, Daniel, relied very heavily on Justice Gorsuch's concurrence, which I think makes a lot of sense because the Chief's majority opinion, it's a little more elliptical, whereas Justice Gorsuch's concurrence really spells out very clearly what he sees as the elements of a major question and what factors courts should be considering. I think for the non-lawyers here, concurrences usually are not binding on us lower courts, and the majority opinion is. However, from time to time, you will see a concurrence that ends up being very persuasive, very important in the development of the case law. Sometimes even more important and more impactful than the majority opinion, arguably. And I think it'll be interesting to see if this is one of those rare concurrences, Justice Gorsuch's, that ends up really driving the case law in the future. Sarah, the framers expected that members of each of the three branches of government would zealously guard their institutional prerogatives, ensuring that power would check power. To reference the Federalist Papers. Implicit in Daniel's comments is the concern that maybe legislatures' incentives haven't worked out as the framers expected, that maybe it is what is in individual electors' interests to pass broad delegations of power to executive agencies. In other words, legislators' individual interests don't align with their collective institutional interests. I'd love your reaction to that idea. Is this happening, and should we be concerned about it? Does this suggest that the executive branch and ultimately unelected bureaucrats are gaining power at the expense of the people's representatives?
Sure. So my favorite line from the Federalist Papers, the interests of the man must be connected with the constitutional rights of the place. But Madison and none of the others sort of explained how that was going to happen. Like, how do you tie members' own incentives to the institution's incentives? So as Daniel suggested, and I agree completely, that members' individual interests, electoral interests, as well as their party's electoral interests at times, right, encourage delegation, for sure, ambiguous delegation. So I think if we are worried, as we should be, about power ceding to courts and unelected bureaucrats, I mean, I think the inherent institutional problem here, with all due respect to the House Oversight and Senate Oversight committees and subcommittees, right, delegation is supposed to go hand in hand with oversight, right? Conceptually, that's how we deal with the fact that we've delegated so much power, is to hold agencies accountable for how they're using it. But of course, that's just another problem, because members often don't have much electoral incentive to invest in oversight. And so one might wonder how well the oversight is being conducted, even as they're delegating, as Daniel said, like hundreds of statutes that have ambiguous provisions. So I think the broader problem, especially in a period of very intense partisanship, right? Your team's for it, so my team is necessarily against it. Like, how do you get members to care about the institution? The framers, I don't think, were too much help.
What do you think about that, Daniel? And have you seen, do you have any sense of, has there been a change in this? Has this always been a problem with the structure of Congress?
I doubt it. I really think that a lot goes back to the intelligible principle standards first articulation by the Supreme Court. That's really sort of what let the cow out of the barn, so to speak. I will say a word on behalf of the Oversight Committee and its counterparts in the Senate. We are quite vigorous most of the time about our duties. I think part of the problem is that the society generally over the last many decades has fallen into a mode of expecting continual addressing by Congress of major new questions as they arise. And so for the authorizing committees, who may have a term before, 2 terms before, 3 terms before, 4 terms before, passed a major issue, for example, Dodd-Frank, from financial services and Senate banking, in the terms in which they might be exercising ferocious oversight, they're often bombarded with ferocious demands to attend to new legislative problems. And so resources are limited, and it's hard. It's hard for the authorizing committees to devote the time to oversight that they might want to. It's a tough nut to crack.
I wonder if the oversight function is, if that actually buttresses this idea, though, that maybe the framers were not really what the framers thought. I think was that Congress, they were typically thinking of enactment and presentment of new statutes that would have to attract at least a majority of both houses and the president's signature. And what we have in oversight, though, is often individual members or maybe a collection of individual members who can be quite powerful and have a lot of individual influence, either encouraging or scourging an agency for the agency's actions. And so it occurs to me that it's possible what we have here is that maybe what would be in Congress as a body's best interest is for it to be making decisions through enactment and presentment on these hot issues of the day, rather than passing very broad, opaque statutes that give a lot of power to agencies on the front end, and then individual legislators on the back end to either say, hey, agency, why aren't you doing this? You know, look back at this opaque statute we passed 10 years ago, you could do this. Or what are you thinking?
Yeah.
But either way, they don't have to bother with the process of two houses of Congress.
I hear you. I think there's a lot to be said for those comments. I would just make two observations. One is that when the framers were framing, they really did think that they were vesting all legislative power in the Congress of the United States. I don't think it ever occurred to any of them that the institutional features and incentives that would be bearing upon members of Congress would include the ability to delegate so much out to the executive branch to set policy. So I think they would have been surprised by that, and therefore didn't address it. Two, bear in mind, I think that a lot of very effective oversight, broadly speaking, actually happens during the appropriations process, and agencies hew very closely to that, and members are very attentive to the money that's being spent. So perhaps it's not as dire a situation as the comment suggests, but I certainly understand the impulse.
Well, we've come to the most important part of the program, and that is to hear your questions from the audience. We've got a great group, large group, and a lot of people with a lot of good information on this. Let me just ask that if you rise, you speak briefly, and they have a question mark at the end, so we can give our panelists an opportunity to respond. Don't want to scare people off, though. Any questions? I think we have two handheld mics. Yes, ma'am.
I'm going to ask this question while the lawyers in the room are getting together their real administrative law questions. But what comes to mind as I listen to your discussion is along the following. All right, so when Congress delegates to an agency, it's effectively delegating to the executive branch. So as we've learned, and of course the executive branch includes the president, so he doesn't need explicit statutes. He can also take power under the guise of an emergency. We saw that with COVID, the student loan question. For all we know, there are plans to enact parts of this Clean Power Plan under a climate emergency doctrine. How does this filter into the way the court would review? And then, of course, we realize there's a problem that Congress won't sue. If Congress is in the hands of the president's party, they won't sue to get that power back. How does that filter through in terms of these real major questions that are facing the country now with respect to not going through an agency, but just going between Congress, a statute, and the president's office?
It's a good, excellent question, and I think our lack of attention to the presidency is a good sort of correction here. This isn't quite the answer I think that you may be wondering about, but I mean, I don't think that when the president takes acts unilaterally, that power has necessarily flowed to the executive branch or the White House, because there's often no clear statutory basis for it, right? Whether it was the moratorium with the CDC, or, as you said, the student debt, right? Or the immigration's the clearest case, right? The Obama administration goes forward with DACA, and yet it just wound up in the courts. So I don't know. On the one hand, we think, well, Congress is losing power here, but I don't know that it's a zero-sum game, right? That another institution is recouping the power. But it certainly leaves a lot of power in the hands of the courts, for sure, to decide whether either actor's gone too far.
My own instinct is, the court will have different tools, different doctrines, different lines of precedent to address the different problems. When the president's acting, I suppose, he's either going to be acting pursuant to faithfully executing the laws Congress has passed under that Article 2 duty that he has, or he's going to be exercising his own power in foreign affairs or to conduct the national defense. And there'll be different doctrines under different case law to apply to different exercises. So I suspect in a case like you described, using emergency powers, it would be just a different mode of analysis that the court would largely engage in than what it was dealing with in the major questions case.
Perhaps worth just noting, I think something that Dr. Binder hinted at is that those two emergency docket cases, while they both involved agencies, it was very clear presidential involvement. The CDC eviction moratorium from last summer, you all may recall, there had been a statute that during COVID that had told eviction moratoriums. It expired. The CDC entered this unilateral agency directive. It went up to the court the first time, and there was this really interesting split where Justice Kavanaugh ended up being the swing justice, basically saying what you're doing is illegal, but since it's about to expire, I don't think there's irreparable harm here. The agency action did expire. President Biden famously or infamously said, well, the court had spoken, the Congress needs to act. Congress didn't act. I think a couple congressmen actually started protesting or something on the steps of Congress, and Biden changed his mind and said, well, I guess we will act unilaterally, and of course acted through the CDC. So I think in a lot of cases, and the mask mandate as well, NFIB versus OSHA, I think that was very closely associated with the White House, even though the rulemaking came through the agencies. So my guess is that even though in a lot of these high-profile cases anyway, they're going to be, the White House may be driving something, but it would happen through one of its agencies. Other questions? Nick.
So I guess the question for the panel is brought up a bit by the discussion of oversight by Congress. Obviously, Congress is very, very familiar with the law that it has recently passed. These are often the subject of long debates and discussions. But there are also lots and lots of laws that have been on the books for tens, 20s, hundreds of years even. And it strikes me that a lot of the cases that we've talked about, there are cases of old laws that the agency is putting to very new purposes that often seem very outside of what the Congress originally enacting that legislation might think of. Clean Power Plant, the OSHA mask mandates, you think of the CDC housing regulation, you think of the 9/11 Act for student debt relief. These are not statutes that were designed to deal with that problem. They're actually federal statutes. So I guess one question is, especially if this does tend to come about primarily as a doctrine, about taking very old statutes and applying them in new circumstances, Professor Binder, would you still have some of the same concerns about this deterring Congress from being able to compromise by passing new statutes? Because it's a little different when you're talking about a statute that just came out and using ambiguity there and solving the problem in a different way from a statute from the 1970s or from my world of telecommunications in the 1930s, suddenly being able to completely new and different purposes.
That's a great question, and I think we haven't quite addressed it yet. And I do think it points to a reason why one might want a very effective major questions doctrine. But I also think it just gets us back to the original point, which is how, or maybe one shouldn't, but how does one legislate for the future if you can't identify what the problems will be? And maybe one response to that is, well, you shouldn't have such long-lasting statutes. And that's a certainly plausible answer. It's not the one that Congress does for all sorts of capacity issues, let alone political capacity or will to revamp and go back to statutes. But if you think that Congress should be writing statutes that have some staying power, then we're back to the conundrum of how do you express intent if it's a future use? And it's worth thinking a bit more about whether this is something Congress shouldn't be doing, or whether there's an avenue or some way for them to think about how to draft statutes in a way that might have some future applicability. But I think it's a tough challenge for folks who are resistant to the idea that the court should be distinguishing about these different types of delegations.
If I could comment too, I think in many ways sort of the question sort of highlights the divide in the polity between those who I'll say are more originalist in terms of the desire they have for the government, and those who are more progressive. The framers, I think their response would have been, well, if Congress doesn't yet know what the problem is, Congress should be doing nothing and leaving a free society to use the means at its disposal as problems do or do not emerge and society goes about its business. Someone with a more progressive outlook may be more inclined to embrace the idea of having a flexible open-ended statute that stays on the books for years so that government can be addressing whatever the problem is that arises as the primary means of addressing the problems.
Just flag, this is one of the factors that Justice Gorsuch explicitly mentioned, as Daniel said at the outset, that he said courts should be looking to the age and focus of the statute in question. So I don't think it is, it's not coincidental that, as you say, almost all of these significant cases involving the major question doctrine have precisely arisen where you have Congress or an agency trying to do new stuff with a very old statute. Any other questions? All right. Do we have time? Can I ask the panelists one more?
Sure.
I was just gonna. One thing I mentioned at the beginning is Brown Williamson was a Chevron case. I don't think we've discussed the fact that this last case did not involve Chevron or did not invoke Chevron at all. I wonder if you all have any thoughts about what this means for Chevron.
I don't know. I was surprised by that. Myself, when I took in the oral argument, I was thinking to myself, well, if I had to bet on this, I would bet a majority of the court would just narrowly and simply hold that Section 111D of the Clean Air Act, interpreted its Step 1 of Chevron, does not grant the agency this authority. So done, and no new ground broken. And that's not what happened. And given what happened in the majority opinion and in Justice Gorsuch's concurrence, I'm surprised that the dissent didn't say more about Chevron either. To me, that's a little bit of a tell that the real game going on here ultimately is about where in the end do they end up with delegation. Chevron is attendant upon a delegation regime, and people may be beginning to sense the end of the existing regime. So maybe that's why the focus was elsewhere. Just my speculation.
I'm going to say simply that Daniel put that very, very well.
Thank you.
Those were well put. So give him last word.
Thank you. I'll get back to Steve.
Thanks, Judge. Please join me in thanking this excellent panel for sharing all their insights with us.